Hello everybody, it's Chris Clark with DiscGolf.Law. I'm back with you today to discuss one of our favorite topics, intellectual property protection in disc golf. Before you scroll away, I want you to hear me out. You'd likely be shocked at the number of major disc golf companies that haven't taken even the most basic fundamental steps to protect their valuable intellectual property. We continue to believe the consequences for the disc golf industry around this issue could be huge. We've done lots of videos on this topic before, but not enough of you are listening. Now, this isn't meant to be a "we told you so" video, but many of the things we predicted years ago have turned out to be correct. For those of you out there who didn't take this topic seriously before now, you're in luck. MVP Discs has given us a good reason to take another shot at getting this message across. On December 14th, MVP applied for trademark protection for balance. That was the trademarked term that they applied for discs for playing disc golf. Those were the goods that were claimed in the application. The balance is a disc in MVP's Simon line, and MVP has stated that the balance is an important brand in the Simon line of discs. Now, the first important point to understand, MVP's application for balance was filed on an intent to use basis. So what does that mean? When you file a trademark application, you must either file on an actual use basis and include proof of the applicant using the trademark in commerce. This proof is referred to in trademark law as a specimen of use. But if you're not using the applied for mark in commerce yet, as was the case for MVP when it applied for the balance trademark, you must file your application on an intent to use basis. Then submit your specimen of use at the appropriate time in the future, which typically would be whenever you can prove actual use of the mark in commerce in association with the goods claimed in the trademark application. Here's where it starts to get a little interesting. On October 28th, MVP published a new page on its website called Statement on Trademark Law. On that same day, MVP published another new page on its website called Statement on the Balance. The article begins with a short history and the PDGA's recent approval of the Simon line balance prototype. The article quickly shifts to a description of a trademark dispute MVP is currently facing with Essential Discs. There is a disc currently PDGA approved for the name Balance. Why are we submitting a disc name that has technically already been approved by the PDGA? The answer there is that MVP believes we have already secured the trademark application priority date to the name Balance for use in disc golf. Okay. Securing a trademark application filing date is easy and is mostly legally irrelevant, at least when it comes to ultimately determining which party has the rights to use a particular trademark in commerce. Trademark rights arise through use in commerce. And sometimes situations arise where one party has been using a particular trademark in commerce for a period of time without ever filing for any trademark protection. This happens all the time. And then a different party files a trademark application for an identical or confusingly similar trademark. I could file an intent to use trademark application today for a flying disc called a zone. Today would be my trademark application priority date, and based on our quick analysis, there's a decent chance, provided that Discraft doesn't oppose our application, there's more on that in a moment, that my intent to use trademark application would likely be approved. Does that mean I have superior trademark rights to the zone over Discraft, it does not mean that. But in situations like this, both sides had better get out their calendars and their wallets, because this scenario I just described, one party without having done any trademark work, been using the mark in commerce, and a separate different party who has not been using the mark in commerce but files a trademark application, happens fairly often and is a recipe for an expensive, lengthy trademark battle. Okay, back to MVP's statement. The Simon line brand is extremely important to us, and the development process for discs is a long and arduous one. With those two things in mind, MVP decided to register trademarks ahead of time for names that Simon and ourselves felt were integral to the Simon line. To MVP's credit, MVP has done more US trademark filings than any other disc golf brand of which I am aware. Every single disc golf business must have a sensible trademark strategy in place, or you risk losing market share and possibly your entire business. MVP, to their credit, is setting a good example for other companies to follow. But unfortunately, the trailblazers are often the ones that encounter obstacles or pitfalls along the way. Balance and cameras are inseparable. That's why MVP went through the expensive process of registering Balance as a trademark on December 13th, 2023. Everyone, this statement is incorrect. Just to be clear, MVP submitted a trademark application on December 13th, 2023. It did not register Balance as a trademark. That process is still underway and has hit a few challenges, and it's far from certain whether MVP will ever successfully register Balance as a trademark. MVP is either posturing here or it doesn't understand how trademarks work. MVP's trademark application doesn't provide it with any meaningful legal protection at all. It wasn't until June that we had realized that a company had submitted a disc for PDGA approval with the name Balance in late May. Needless to say, that news was certainly a shock to our system. We reached out to the company to let them know the situation. We assumed that this was a misunderstanding on their part and that we'd be able to find an amicable solution after a quick conversation. However, even after explaining the situation to them, the company was unwilling to budge as they felt their situation gave them priority to the name. Now, Essential Discs is the other company MVP is referencing here. Essential Discs has been designing and selling discs since at least 2014. Other disc golf related goods and services too, such as running events, course design, and coaching. As we briefly mentioned earlier in the video, Essential Discs has, in the past, sold a disc in commerce called Balance, or the Balance. MVP has not, and that's likely an incredibly important factor in how this dispute gets resolved. As you might expect, we were unable to find an agreement over the next few months, which brings us to here. We have the utmost confidence in our registered trademark rights. Again, sorry to repeat myself, but MVP has no registered trademark rights for Balance, and fully expecting our pending trademark to be registered. Well, Essential Discs lawyers have, as of the date of this video recording, filed 2 extensions of time to oppose MVP's Balance trademark application. We usually see this in cases where the opposing party intends to or is considering filing an opposition proceeding to an applied for trademark, but the parties are attempting to negotiate a settlement before they go into battle guns blazing. It's nice for MVP to say they fully expect their Balance application to register, because it gives comfort and confidence to customers and staff and owners and investors. And MVP may well be correct, but there will need to be some heavy-duty negotiations and concessions agreed to, and possibly money paid before that happens. Essential Discs posted a statement online on October 30th, 2024. It is unfortunate about the balance being approved for a second company by the PDGA this year. We have been advised by our lawyers to not make a public statement at this time, despite the misinformation that is coursing around the internet. We have been a supporter of the other company, referring to MVP. They chose to decline any negotiations and made demands instead. If they reached out today, we would still pick up the phone and talk. However, now it is in the hands of our lawyers and theirs. The trademark for Balance has not registered at this point. As a woman-owned small business, we do this for the love of the game and not a love of profit. So, why are we putting so much time and effort into analyzing this issue? Number one, fighting trademark legal battles is expensive. These types of cases demonstrate that it's a good idea to spend a relatively small amount up front on basic trademark strategy to help avoid a costly fight in the future. Number two, the disc golf industry as a whole is likely not ready for another significant, expensive legal battle. In disc golf specifically, unlike many other professional sports, the legal budgets are limited. In 2023, we observed a touring professional player, Natalie Ryan, successfully sue the Disc Golf Pro Tour and the PDGA twice. Recall some of what happened and almost happened as a result of Natalie's lawsuits. FPO division competition was temporarily eliminated from certain Pro Tour events. And although FPO competition was eventually restored at those events, we came dangerously close to having professional women disc golfers either not playing at all or playing at different events at different locations from the MPO field. The statements from the Disc Golf Pro Tour and the PDGA were and remain clear. We don't have the resources to fight expensive legal battles. Number three, there is fairly consistent evidence that the disc golf economy overall contracted in 2024. Now, there are some exceptions, and I don't think the sky is falling, but it's safe to assume disc golf company bank accounts aren't as healthy in 2024 and 2025 than they were even just a couple of years ago. And number four, rebranding is an expensive nightmare. Sometimes we hear comments like, well, one party or the other, they should just change the name. Well, that's a lot more complicated than it sounds, especially if the process of manufacturing physical goods bearing the trademark has already started. We've counseled clients through rebranding many times, and it's one of the most painful processes a company can go through. If you need to rebrand and your goods or services are still in the idea stage, and you haven't spent a bunch of money on securing a URL, having a logo and a website designed, getting prototypes built, and those types of things, then you're one of the lucky exceptions to this rule. We assisted a client with a rebrand that had 7 figures worth of products on a boat coming to the US from China, and those goods all had the company's infringing trademark stamped onto them. Those goods had to be destroyed, having to pay legal fees and possibly pay a judgment or a license fee to another party, and having to destroy a bunch of goods that you've paid for. This is a special form of hell that well-intentioned trademark infringers must endure sometimes. Not every time, but it does happen. Putting this video together was challenging for a few reasons. I have great respect for MVP as a company, and my professional interactions with MVP have almost always been positive. I hold MVP up as a shining example of how disc golf companies should be approaching intellectual property protection. My issue with MVP as it relates to what we discussed in this video is that the information posted on the MVP website about the Balance trademark situation is in some cases misleading and in others flat out false. Information in the United States Trademark Database is publicly available. We can see the file history for MVP's balance application, and so could you. We can learn a lot from reviewing the file history documents, but they don't always tell the full story. We do our best to have conversations with people we know and pick up tidbits from social media posts and press releases, but we acknowledge there always can be relevant facts that are hidden from our view that could change our analysis of the situation. On this video, just like all our videos, if we get something wrong or we missed something, we welcome the opportunity to be corrected. Trademark law is highly nuanced and sometimes not very intuitive. I mean, there's a reason that entire semesters of law school are spent studying intellectual property, and in some cases, just trademark law alone. We've had to intentionally leave relevant information out of this video to avoid having it end up being an hour long. I tried to come up with a summary of what the potential next steps and eventual outcomes might be, but at this stage, there are too many, and it would take too long. We will get back to you as soon as we have a meaningful update. In the meantime, please let us know your thoughts on these issues in the comments. We have seen and heard lots of comments about this situation on various internet and social media platforms and podcasts. And frankly, a lot of the information we have seen is wrong. So if you have questions, please leave them in the comments. We'd love it if you would like this video and subscribe to our channel. As always, thanks for watching.